welcome to the Society of Construction Law Australia's podcast of the inaugural 2023 Stynes Address. My name is Kiri Parr, and I am a Director of SoCLA and Chair of its Academic Committee. In 2023, the Society of Construction Law held its inaugural Stynes Address at the State Library of Victoria. The Stynes Address is an annual lecture set up to provide a platform to hear from our industry's leaders who are driving change in the construction industry. The inaugural address was given by SoCLA's patron, Justice Katie Stynes, after whom the address has been named. In her honours words, she hopes the Stynes Address will offer something a little different, to share ideas that challenge industry views and that cause us to question how we do our work, how we serve our industry, and whether there is a better way. In 2023, Justice Stynes talked to us about the procedural reforms she is leading from her role as judge in charge of the technology, engineering and construction list of the Victorian Supreme Court. We hope you enjoy listening to the 2023 Stynes Address.
I begin today by acknowledging the traditional custodians of the land on which we gather and pay my respects to their elders past and present. Thank you for that very warm welcome. I am honoured to have the opportunity to address you this evening for the inaugural Stynes Address entitled Disrupting How We Use Pleadings in Complex Construction Disputes. I know pleadings, right, but get ready to get excited. It is going to be more interesting than it sounds. I am flattered that this lecture series bears my name, maybe also a little bit embarrassed, but not so much so that I would turn the honour down. And I thank SoCLA and its members for this honour. Now, SoCLA provides numerous events when we gather and share our knowledge and make connection. And it's my hope that this lecture series offers something a little different, and specifically to provide a formal and ongoing opportunity for us to come together and share ideas that challenge the industry views and challenge the norms that we've come to accept, ideas that cause us to question how we do our work, how we serve our industry, and to ask whether or not there's a better way. I'm excited to go first. I always like a captive audience. And I want to put forward an idea that's been brewing for some time that challenges how we deploy pleadings. And I raise it now against a series of changes I've been making over the last few years. And I think now's the time where we challenge pleadings head on. But before I do, let's have a look at the general lay of the land. The traditional sequence of events in litigation, in overview, is pleadings, discovery, lay evidence, expert evidence, and trial. And some of you have been attending other lectures I've given where I've addressed the other case management techniques that I've introduced, which have really aimed at disrupting that traditional sequence with a view to getting to the issues in dispute a little earlier. And what those techniques are, there's three I'll just run through very quickly. The first and the obvious one was bypassing discovery and instead requiring the parties to prepare and file their lay evidence together with tender bundles of documents that the parties intended to rely upon. And currently that step follows the close of pleadings. Second, and probably the most dramatic change, was requiring experts of like disciplines to participate in two conclaves shortly after the close of pleadings. The purpose of the first conclave is for the experts, in the absence of their legal representatives and parties, to confer and agree on three things: the issues to be addressed by them, the methodology they propose to adopt to address those issues, and the categories of documents they require to attend to that task. The second conclave occurs once the categories of documents they identified have been collated and provided to the experts, and it's usually about 6 weeks after the first conclave. And so again, this is shortly after the close of pleadings. And the purpose of that second conclave is for the experts to confer in relation to the issues to be addressed by them to see if there are areas of agreement. And if there are, they're noted. And then thereafter, the experts write their reports in relation to the areas of disagreement. So already we're seeking to narrow issues in dispute. And what the sequence of these early conclaves aims to achieve is to ensure that the briefing process of experts is totally transparent. And more significantly for me, it results in experts providing evidence on the same questions, based on the same materials, and employing the same methodology. The third case management technique I introduced is what's been referred to as the case management conference, for want of a better term. And these CMCs are fixed for about a day, maybe two, depending on complexity, and they occur about 2 to 4 months in advance of trial. And the purpose is to provide each party an opportunity to address the key issues in dispute, the 3 critical issues, maybe 4. They address those issues with me, including identifying the key evidence relied on, lay and expert, and the documents that they want to rely on. Not breadth of documentation, but the key pieces of material. Now, each of these techniques was introduced for the paramount purpose of assisting the parties identify issues in dispute early in the proceeding, as early as possible. And they disrupted the traditional sequence of events by bringing forward the preparation of evidence and largely dispensing with any traditional notion of discovery. But as I discussed at my last presentation to SoCLA, the interlocutory process I'm most keen on having a close look at now is pleadings, and that's the subject of this evening. As construction lawyers, we are well familiar with the challenge of trying to plead a claim and defence at the commencement of a proceeding at a point in time where we haven't yet got a handle on the large volume of documentary evidence that's potentially relevant, and certainly we don't have the expert opinion in hand. And that is pretty challenging in complex tech cases, and yet that is what we're currently required to do. It struck me that there must be a better way. And let me expand on 2 key problems I see with the current requirements of pleadings as they apply to complex construction disputes. And I stress here, that's the nature of the disputes I'm concerned with tonight. The first problem is the time and money spent on pleadings. My associates, Yaz and Sam, who are here this evening, they've undertaken a review of my current and finalised tech list matters and managed to identify some pretty important data. On average, these are average figures, in a tech list proceeding, the parties will spend just shy of 18 months in the pleading phase. That's the average amount of time across all my matters. And over those 18 months, there will be 3 rounds of amendments to those pleadings, and over half of those amendments will occur after at least one party has filed their lay or expert evidence. It's also worth noting, in relation to tech list proceedings that resolve before trial, 80% of those settle after evidence has been exchanged. Now, that's probably not surprising, given the parties are unlikely to be in a position to assess the merits of the claims or defences until after that evidence has been exchanged. But this is the reality of tech list matters. Obviously, each case is unique, and this data doesn't tell you anything about the reason that there are amendments. But they do reveal what we know to be true, that it is challenging and time-consuming and expensive to plead a claim or defence in complex construction disputes ahead of lay and expert evidence. The second problem I've observed with pleadings in complex construction disputes is that their current form, notwithstanding the time and money spent on them, they don't always or often serve the purpose of clearly articulating the claim or defence. So what's my evidence of that? All the steps that we all take to reshape the information in the pleading to meet our purposes. We produce summaries of pleadings in a narrative form to advise our clients of the case they have to meet and the merits of it. I don't believe for a moment that any of you simply send the pleading to the client for them to read and digest. We produce pleadings matrices for the purpose of analysing evidence. We produce Scott schedules of defects and variations to pinpoint relevant materials. And ahead of trial, we've all become accustomed to being ordered to confer and agree list of issues in dispute, which are going to be the subject of submissions. So the central thesis of this address is that a traditional approach to pleadings in terms of timing and form is not the best and most efficient way to identify the real issues in dispute in complex construction disputes. To the contrary, in my experience and observation, the approach serves to cause delay. And if that's right, and it's obviously just my view, I think it's incumbent on us to find a solution. Before I get rid of pleadings, let's have a look at what they do and what purpose they serve. Put simply, they are a formal document exchanged between parties to civil litigation which are intended to contain, in a summary form, a statement of the material facts on which a party relies. The exchange of pleadings is intended to define the issues in dispute and the parameters of the litigation, and it's been employed for that process for over 500 years. To this day, it is a process perceived by many as essential to the proper and just determination of disputes. Now, in my view, it's possible and important to distinguish between the form and function of pleadings. The central contention of my presentation and my current thinking is that the function served by pleadings is essential. The form and timing of the material that serves that purpose is ripe for change. So when I refer to the form, I mean the document itself. Here's a list: the statement of claim, a defence, usually a reply, perhaps a counterclaim, followed by a defence to counterclaim, and then a reply to that defence, perhaps a third-party claim, or multiple in complex construction disputes, and then the related defences to those. Each of those documents is invariably long, legalistic, and formulaic. And when I refer to the timing of a pleading, I'm referring to the current requirement that they be produced at the commencement of the proceeding, ahead of lay and expert evidence. Coming back to the function of pleadings, which I think should be preserved, it's simple and widely accepted to define the issues in dispute and to provide notice of those issues at the earliest possible stage. By defining the issues in dispute, pleadings also serve to define the range of admissible evidence and define the scope of discovery, where discovery is still provided for, but not with me. There is a presumption inherent in the institution of pleadings that the parameters of the issues in dispute are fully capable of identification at the outset of the proceeding. And in my experience, that presumption almost never applies to the kinds of disputes that we work with. They rely so heavily for issue identification on expert opinion and large volumes of documentary evidence. Nevertheless, we pressed on with the traditional approach to pleadings, imposing a significant burden on drafters. Before they had the benefit of lay and expert evidence, drafters must proceed to commit to a set of facts said to underpin their client's claim. And understandably, they err on the side of caution and over-include potentially available causes of action and facts that are potentially material. That caution is understandable and born out of fears pending the completion of evidence that they could omit critical details that will result in losses for their clients. And herein lies the conflict between a lawyer's duty to advance their client's interests and the objective of pleading to identify those issues that are genuinely in dispute. Pleadings are frequently formulaic, a classic formula for a statement of claim in a complex construction dispute. Parties, project, contract, terms, performance, breach, relief. Now, there is a comfort in that list of headings for a drafter. I understand, I've been there. But can I suggest it is not the most efficient presentation of a claim? If a statement of claim is set out in that way, and let's say it's 50 plus pages, and I start reading on page 1, I won't know the cause of action until after page 35. Personally, to overcome this difficulty, which I read many sets of pleadings each week, I start reading the pleading from the back. First, I see who drafted it, and then I read the prayer for relief. I'm trying to work out if this is a claim in contract, in statute, or in equity. I then scan the paragraphs under the heading breach or similar heading to see how the breach is described. I then scan, very at a high level, the paragraphs describing the chronology of events to identify the specific conduct said to constitute the breach. Now, I don't think that my approach is unusual. I suspect you all have your own systems. Just imagine for a moment how you could describe a breach of contract claim you are about to plead to your plaintiff client. I sincerely doubt you start by identifying the parties in their legal capacity or by reading the numerous terms of the construction contract that may become relevant. To the contrary, I imagine you would explain that the claim is for a sum of money, around $1 million. The defendant might be liable to you because they breached the contract. Specifically, they breached Clause 12. That required them to deliver the materials by a particular date. They didn't. They provided it over time. That caused delay. And that delay is going to need to be assessed and quantified by an expert. Our best estimate at this time is it was a delay of a month. Now, that is clearly a simplistic example, but it makes the point that you don't need to employ formal or complex language, and you don't need 30 or more pages of facts to convey the nature of the claim, a breach of contract, the specific conduct relied on, delay in the delivery of material, or to reveal the types of expert evidence that may be required, a delay expert, potentially a QS. While we continue to employ pleadings in the traditional way, we are going to continue to expend significant time and money drafting them, amending them, resolving applications for further and better particulars or for strikeout, and reviewing pleadings and reformulating them for our various purposes, including in an effort to identify issues in dispute, the very task that they are intended to serve. But that function served by pleadings to define the issues in dispute is important. The question I raise is whether pleadings, as they currently stand, properly serve that purpose. And my observations and concerns about pleadings are not novel, and they've been addressed in academia, in law reform proposals, and by the courts. The limitation of pleadings was identified some years ago quite clearly, I think, in the full court of the Federal Court in the case of Betfair and Racing New South Wales. The court stated, pleadings are a means to an end and not an end in themselves. A question of concern to the court in that case was whether the respondents knew of the case they had to meet. And the court said this: Betfair's opponents sought to rely at the trial on the general proposition that Betfair would be held to its pleaded case. An announcement of that kind by a party misstates the party's capacity to direct the course of the proceedings. The course of the proceedings is in the control of the court. That control is to be exercised for the attainment of a just outcome. There will obviously be cases where a pleaded case does not raise an important fact for attention, and if that remains the position at the end of the case may be lost on that basis, so far as it depends on that fact. Sometimes it would be unfair to allow a party to amend a case or a pleading to raise a new matter which could have been, but was not raised earlier. On the other hand, mere infelicity of drafting will rarely be allowed to defeat a case on its merits if the merits of the case have been made apparent on the evidence without unfairness to the other party. Their Honours went further to highlight the tension between the notion of restricting disputes to pleaded matters and Section 22 of the Federal Court Act. That provision requires the court, as far as possible, to determine all matters in controversy completely and finally, And that provision is mirrored in subsection 29(2) of the Supreme Court Act, which relevantly requires the court to exercise its jurisdiction in every proceeding before it to secure that, as far as possible, all matters in dispute between the parties are completely and finally determined, and all multiplicity of proceedings concerning any of those matters is avoided. The High Court has also directly engaged with the paramountcy of the real controversy over any rules of pleadings in Vale and Sutherland. They remind us that cases are determined on the evidence, not the pleadings. So the principles I draw from the case law, and I've just taken you to bits and pieces, is that pleadings are a means to an end. If the evidence raises fresh issues for determination without unfairness to the other party, then it is the evidence that will serve to frame the dispute. And I raise these principles and identify them for your attention because we live in a world of construction disputes where evidence, both lay and expert, is exchanged well before trial and currently quite some time after the close of pleadings. Who are we kidding to think that pleadings are doing the task that they're intended to do? In my experience, the identification and narrowing of issues in dispute in complex construction disputes is far more readily achieved as a result of the following interlocutory steps, each of which currently postdate the close of pleadings: the exchange of witness statements, the exchange of expert evidence, the identification by each party of documents they intend to rely upon, maybe mediation, and maybe the CMCs. Before addressing what I think will be the best way forward, I want to highlight a few examples of other reforms to pleadings made in other jurisdictions that I think dispel the idea that any suggestion I'm making is at all in any way radical. Alternative forms of pleadings in construction disputes have already been trialled and tested with success in other jurisdictions and forums. And a simple and well-known example is the Scott Schedule. That is a table in which the plaintiff itemises its allegations and the defendant then inputs its responses, each with reasons. In that form, there's no room for non-specific allegations or bare denials. Scott Schedules are useful, I think most useful, in cases where there are repeat forms of claims like variations or defects. And they enable extensive and complex information to be summarised succinctly. Scott Schedules have been used in the Technology and Construction Court in the UK for decades, and they've been implemented in the Australian jurisdictions, including in my list. Usually a Scott Schedule will form part of the pleading. In certain cases, it will replace the pleading. For civil litigation more generally, some of you are going to be familiar with the federal court reforms which saw the introduction of the fast track program, which has laid the ground for proceeding by way of a concise statement. Now, the concise statements can be used in lieu of a formal pleading or as a triaging mechanism which precedes a formal pleading. Now, the Federal Court's implementation of a concise statement has been a bit mixed, and recently we've seen Justices Derrington, Button and Beach caution against their use in substitution of pleadings in complex cases where they say precision, clarity and rigidity are required to fairly inform the opponent of the case made against them. Well, I read those cases to serve to remind us that pleadings serve an important function and that the function must be maintained even if the form is changed. In the Supreme Court, in commercial cases concerning claims of oppression under the corporations legislation, it's pretty commonplace for proceedings to be commenced by originating motion, for there to be a simple exchange of affidavit material before the matter runs quickly to trial. And in complex construction disputes that proceed to arbitration, of course, it's commonplace for the parties to exchange memorials comprising their evidence together with their pleading. And of course, I'm using pleading in that sense in rather loosely. It's often presented as a summary of issues in dispute in a narrative form, and the drafting is obviously informed by the lay and expert evidence, and that is a distinct difference between pleadings in the traditional sense and those memorials. Before I move to propose what I boldly suggest is a better way forward, I want to repeat that the purpose of this address is to open up a dialogue between us about how we might do better than traditional pleadings. I don't profess to have the best ideas. I don't profess to have thought every issue through that may arise from my ideas. And I'm using this platform to invite suggestions and criticisms and to start the conversation. And I'm inviting you specifically to ask, how can we do better? So following a broad review of academic papers, law reform materials and judicial decisions, and upon reflection of my own experience as a practitioner in construction litigation and arbitration, this is what I think will work. Proceedings would be commenced by a generally endorsed writ. The defendant would enter a notice of appearance, and the parties at that point would attend court for directions for the purpose of timetabling the exchange of a concise statement of case and a concise statement of defence. The statement of case would have the following features. It would identify the causes of action and, at a high level, the material facts supporting the elements of those causes of action. It would provide sufficient detail of the causes of action to reveal the issues in dispute that may be the subject of expert evidence and the expert disciplines that may be required. It would adopt a concise narrative style, avoiding legalese, a document in the style of the summary of the claim you might provide to a client when you're explaining what's going on. It would reference by footnote or annexure those documents critical to the matters in dispute. That is the kind of document you have an obligation to disclose from the commencement of proceeding going forward under Section 26 of the Civil Procedure Act. The concise statement of defence would adopt the same or corresponding features. The defendant is expected to share what it understands are the material facts relevant to the issues articulated by the plaintiff and which may support a defence of the claim. And of course, counterclaims in any following documents would adopt a similar form. It's significant that these documents are not being produced in a vacuum. Complex construction disputes only get to court after the parties have worked their way through the alternative dispute resolutions embodied in the contracts between them. Indeed, those procedures invariably require, as a first step, the production of a notice of dispute and response. Second, litigation usually only follows after the parties have engaged their own experts to help them comply with contractual obligations or otherwise engage in a meaningful way in the alternative dispute resolution procedures. And as a consequence, I don't anticipate the production of the concise statement of claim and defence will take much time. I'm talking a matter of weeks, not months. Now, the purpose of these documents is not to once and for all time define issues in dispute. Instead, they're designed to facilitate the commencement at the earliest possible time of the interlocutory steps that do in fact allow us to fully consider the issues in dispute. The exchange of critical documents, the exchange of lay evidence, the early expert conclaves that I've implemented in the tech list. Following those interlocutory steps, on a case-by-case basis, the parties and the court may consider what, if any further steps are required to ensure the parties are properly informed about the case they have to meet. Now, the timing of that consideration might happen after the plaintiffs have put on their materials, or it might wait until all the parties have put on their materials. Maybe a party armed with all of its evidence that it intends to rely upon should be required to prepare a more formal pleading to clearly articulate the parameters of the case that they're agitating. It's my expectation, if that's the case, that document is going to be a completely different beast to the pleading that would have been produced at the commencement of the proceeding absent that evidence. Maybe the parties would simply be assisted by an agreed list of issues in dispute and can move forward on that basis. So, to summarise, the reason why I suggest there is a need to reconsider the form and timing in relation to complex construction disputes is that in most cases, the parties simply cannot meaningfully plead and particularise their claims or defences ahead of the preparation of lay and expert evidence. And second, the form of the pleadings currently produced in the absence of evidence are legalistic, formulaic, expensive to produce, and often, and understandably, not fit for the purpose of identifying the issues in dispute. The mischief I'm seeking to address is the 18 months spent by the parties on average in pleading complex construction disputes. My vision for complex construction disputes in my list is simple, and I've held it for a long time and I am working towards it. It's taking a bit of time. Commence the proceedings. Identify concisely the nature of the dispute. Complete the exchange of lay and expert evidence with or without more formal pleading within 6 to 12 months of commencement of the proceeding. That's it. That was the target I set. That's what I'm working towards. This is another step towards it, I hope. Compare that vision to what I've experienced in relation to complex construction disputes employing a more traditional approach. 12 to 18 months in pleading, followed by 6 to 12 months in discovery, followed by 6 to 12 months in lay evidence, followed by 6 months in expert evidence. It makes me uncomfortable thinking of any of my matters that have suffered that path. It seems like I have repeated this ad nauseum every time I stand up to speak, but I cannot stress it enough. The tech list is unique and it demands an appropriately tailored procedure to dispute resolution. It may be that this proposal would be suitable beyond the tech list, but that's for someone else to consider and test. I'm not looking there. My focus, my passion, is directed to optimising the procedures for resolving construction disputes by determination or negotiated settlement in the Victorian Supreme Court tech list. That's my focus. And I'm really asking you, I'm inviting you to engage with me to consider my proposal and the mischief I'm seeking to address, and let me know what you think and how we can do better.
We hope you enjoyed this episode, and we look forward to seeing you in person at our next Stynes Address, held in November each year. Check out the SoCLA website, scl.org.au, for the next event.